de voir avec nous aujourd'hui le département du cabinet du procureur général ici.
We are pleased to have the Office of the Attorney General with us. I am pleased to welcome his staff and the Minister. If the Minister has welcoming remarks, he now has the floor. Thank you, Mr. Chair.
For me to be here today, working side by side with these fine people, who is joining me. These people, these men and women, who works all around the province very hard on a day-to-day basis at the Office of the Attorney General. Donc, j'aimerais d'abord prendre un.
I would like first off to introduce my staff with me today in order to deal with estimates and to explain the budget to parliamentarians on the opposition side. So allow me to introduce first Joanne Gray. She's the Deputy Attorney General of the province. Also, Mr. Guidagde, he is Assistant Deputy Attorney General, and Mr. Davante as well. Kim Pufferoth, Deputy Attorney General Assistant, and also the Director of Financial and Administrative Services. So, Mr. Chair, the budget of the Office of the Attorney General for 2016-2017 is $17,641,000, and to compare, the budget for 2015-2016 was around $17,979,000.
Comprises public prosecutions, legislative services, and legal services. In other words, they are the Crown prosecutors, the drafters of the legislation, and the law firm of the province. And as the opposition members may also be aware, salaries account for almost 90% of the total budget. Cela dit, je me réjouis de la perspective de répondre.
I am pleased to answer your questions and to provide more details on the important work conducted by the hard-working individuals from my department. So without further ado, Mr. Chair, I will be pleased to answer the questions.
For Rousselle.
Thank you, Mr. Chairman. I want to thank the Attorney General for any dealings that I've had with him have been at the utmost professional level. He has at all times conducted himself as a complete gentleman with me as his critic, and I know that sometimes in the emotion of this chamber things can get a little aggressive. But I will say that that's not occurred between us. Any questions that I've ever had for him, he has honestly and sincerely attempted to answer, and I have asked questions only that I believe to be in the best interest of the province. So I do thank the Attorney General for the very professional way. As far as the people around them, I know them all. I have had the good fortune and pleasure in a previous chapter of my life to have worked with the five of them, and in so doing, I have found it to be a very positive experience. They all conducted themselves in the most professional manner, and I will say that as far as public servants are concerned, they're tribute to the province. So thank you for being here. Do you think? I have a little bit of knowledge about these accounts, and I have a fairly good memory, and I know that of all the issues in province that face our province today, there's not very much a department with a $17 million budget can do. I mean, my goodness, if you eliminated the entire department, you would take $17 million off of a $461 million deficit, and you still would be nowhere near anything that even resembles sustainability. So I'm not going to nitpick and things like that. I realize that the vast majority of your budget is salaries, and then from there goes you got a photocopier, phone, and things like that, So there's nothing particularly here that I'm going to spend a great deal of time at. I would be interested to know, though, I think it's a fair statement, and I thank the Attorney General when he said that he was prepared to answer any questions with respect to the finances of the department, as well as any other questions which I may have. And I think that it's a fair statement to say when areas of responsibility are added to your department, or when areas of responsibility are taken away from your department, then there would be pretty much some sort of fiscal impact on it. So, having said all that, a question that has really been on my mind of late is Order in Council 2016-16. And it says under Section 3 of the Executive Council Act, the Lieutenant Governor in Council transfers responsibility for the Judicature Act from the Attorney General to the Minister of Justice, effective February 5th, 2016. For the thousands of people in our viewing audience, tongue-in-cheek, but anyway, the Judicature Act is that statute which governs the judiciary and our court system, plus the rules of court and things like that that are made thereunder. Originally, as our legal system developed, we had the Court of Chancery, we had the Court of Queen's Bench, or the Court of Common Pleas, it was known, which is the court system from which our common law came out of. We had the exchequer courts, we had probate courts, we had admiralty courts. I think there was a matrimonial court, I think, can't quite remember, in England in the 1800s. And we also had this, what were known as the courts of equity, which sort of hovered over the system. And so in England, all of these courts were consolidated. And they changed and restructured this court system. And the courts were organized: civil courts, criminal courts, and the Court of Appeal. And from that Judicature Act flows how our courts are run, how our courts are operated, the rules surrounding those courts, time limits for statements of claim and to respond and document and all that sort of stuff. Very, very much the Judicature Act is an act which is uniquely for the purpose of the legal profession and the practice therein in our court system. So it puzzles me that the government would move responsibility for this act from the Office of the Attorney General to the Minister of Justice. The Attorney General today is a noted legal scholar, is a constitutional expert, is a former professor of law, one of Her Majesty's Counsel learned in the law, legal advisor to government, head of the government's law firm. Why on earth would this be taken away from the Office of the Attorney General and given to the Minister of Justice, a minister who is not a lawyer, has no legal training in law, has no experience. I don't mean to be disrespectful to the Minister of Justice, but the Minister of Justice, compared to the President Attorney General in terms of their knowledge of the law, their understanding of the law, known expertise in the law, it absolutely baffles my mind as to why this occurred. So my first question is why it occurred, and does the present Attorney General believe that it is an appropriate, proper, well-conceived transfer of authority?
Monsieur le Président, d'abord, moi aussi.
Mr. Chair, first off, I would like to thank the critic for Attorney General, the Office of the Attorney General, so I would like to thank him. I always appreciate his questions, and I know that he has an important role to play in our democracy. The opposition is important, and I generally appreciate how he works in a professional manner, so I would like to underscore this. That being said, I also appreciate, and I know that the member opposite knows about my career, and yes, I know full well the history that he talked about before he asked his question, and I would like to remind people that in New Brunswick for a long time, the person who was an Attorney General was generally the Minister of Justice. So over the years, there certainly was some confusion, and even today, people are going to tell me, you're the Minister of Justice, and I need to tell them, no, I'm the Attorney General, I'm not the Minister of Justice. So I think that in the public, and even some lawyers confuse the two roles. So I told this in my presentation earlier. I would like to remind people that the Office of the Attorney General has three sectors. There's the legal drafting services. There's also the legal services. And then there's public prosecution services. So if we summarize, this is lawyers' work. So Attorney General means the general lawyer of the province. But the functions for the Minister of Justice is more about administration of justice as such. So now I can specify that if there's an act where there is justice administration, well, that relates to judiciary organization. So the Adjudicature Act, well, in my opinion, and in the opinion of the government, this is about justice administration. A few months ago, at least during October, I recall that there was a situation where it was under the Adjudicature Act, and I asked, is this really under the Attorney General, or is this the person that takes care of justice administration? And in that situation, there was a transfer of responsibilities. In my opinion, this is because today there's a Minister of Justice who takes care of justice administration, and there's an Attorney General that is the general lawyer of the province. So to answer your first question, why did this happen? I'm a little bit surprised that this didn't happen sooner, because the Graham government and also the Alward government should have talked about this issue, in my opinion. So this is why this happened. It was just to clarify the roles. And also, do I think that this is appropriate? Well, I would like to say that for Justice Administration, the current Minister of Justice has the trust of this government. We believe in his competence, and so yes, it is appropriate that everything regarding justice administration is under the Department of Justice and not under the Office of the Attorney General, Mr. Chair.
Well, that was a very well-beaten bush, I might say, because you beat around it pretty well. Are you aware that the Supreme Court of Canada has found legislation like this in Alberta to be unconstitutional, and that it is an improper dealing by the executive branch of government with the judicial branch? I can get you the case citation, but I'm sure that you're aware of it. That being the case, it strikes me peculiar that your rationale is your fondness for the Minister of Justice as opposed to your fondness for the administration of justice. And again, if I were given my previous experienced government, when I was in government, what probably would have happened is that a memorandum to the Executive Council would have been done up, and it would have involved the signature of both the Attorney General and the Minister of Justice. So I would be curious to know if the Attorney General signed or refused to sign a memorandum to the Executive Council recommending this, because I find it rather odd that everything emanates from just the Department of Justice. So were you consulted on this, and was a memorandum presented to you, at which point you would have said, I disagree with this, I'm not signing it? Or you would have said, gee, I think it's a great idea. Where's the absence of your office here in this? It's something, I guess it's kind of clear. That's what would have happened when I was there. Did that happen when you were there? Were you presented with a MEC to be signed by the Attorney General, and did you sign it, or did you refuse to sign it?
Oui, Monsieur le Président.
Yes, Mr. Chair. I know that in this House we need to ask questions. There's almost a political battle, but I have too much respect for the member opposite to believe that he doesn't know very well the answer that I'm about to give him. The member opposite knows about the privilege of the office in terms of the memorandum to the Executive Council. And I told him earlier that the Office of the Attorney General is the office of the provincial lawyer. And when we give a notice to the government, and he knows that the solicitor-client privilege here applies, so I'm not going to answer the question that he asked, and I'm convinced that the former Attorney General of New Brunswick would probably give the same answer to the question that was asked. Thank you, Mr. Chair.
Well, certainly the Attorney General is legally correct, and he is correct. But you have to remember that confidentiality doesn't mean that he cannot answer the question. It means that he cannot be made to answer the question. Solicitor-client privilege can be released by the client if the client so wishes. Confidentiality can be released if you so wish. So my point is, I can't force you to do this. You're absolutely correct in law, but there is nothing in law that says you can't do it if you want to. I find it if I were a suspicious person, I find it very peculiar that the order in council is dated February 5th, 2016. The Act to amend the Judicature Act was introduced on February 5th, 2016. And it strikes me that there may have been a fair bit of scurrying going on that day. But that's if I was a suspicious person. If you could go back then, I have the following question based upon my experience and my knowledge of the people around you. The genesis of this Bill 21 and the genesis of Order in Council 1616 was the seminal moment, the genesis of this. Did it come from the people working in your department, or did it come from the Premier's office?
Monsieur le Président, donc, je vais pas.
Mr. Chair, I won't try and figure out whether or not the member opposite is a suspicious person. That's not of great interest to me. But that being said, Mr. Chair, once again, I know very well, I'm convinced even, that the member opposite, with all of the knowledge that he has, knows very well that when he's speaking of, and when I'm speaking of, a privilege of confidentiality between a client and a professional, I don't have the ability to speak about this issue. And the advice that's given by the Office of the Attorney General, this cannot be published. And that, once again, this is a matter of privilege and of confidentiality. And if the member opposite has questions about the bill, I invite him to ask those questions to the Minister of Justice.
Well, I did. And I asked the Minister of Justice about this bill, and he said, oh, it was a housekeeping item. And when I was Attorney General, housekeeping items got their genesis from law reform, legislative drafting. Deputy Poffenroth would produce something that this is antiquated. This better describes the law today. It would come forth to my desk, and I would say, yeah, that makes sense. And so my question is really simple. Did this originate with the Office of Attorney General, or didn't it? Now, I was told by the Justice Minister that this was a housekeeping matter only, and that the dates are coincidental. The thought that somebody might want someone appointed to the bench who didn't want to live in a different city, that's if I'm a suspicious person now. That presupposes I'm a suspicious person. I'm not prepared to say that. What this does, and where it comes from, strikes me rather peculiar. And my question is, did the genesis of this come from the people in law amendments, law reform, legislative drafting, and did it come from there? Or did it come from outside? And that's all I asked. The Minister of Justice assured me that it was only a housekeeping matter. But then again, it depends on whether I'm a suspicious person.
Mr. Chair, I must admit that these repeated questions from the member opposite raise a lot of questions on this side of the House, and I'd simply like to repeat to say that the member opposite knows very well that the information that he's asking is confidential, that I am the legal advisor to the government, and I'm bound by the solicitor-client privilege and confidentiality. Thank you, Mr. Chair.
Well, I must say I am in total agreement with the Attorney General when he says this does raise a lot of questions, because it certainly does. The timing of this, I can just imagine the scurrying around. See, because you're an honorable person. You're taking one for the team, and you're doing what you're legally entitled to do, and I have no fault with you. This is unconstitutional. There's a system in place for the judiciary. It's based upon seniority. When a position is open in some part of the province, the person takes that position. As other places open, there's an understanding of seniority. People can move. It may be back to their home. If there's an opening in Bathurst, if you're from St. John, you take that. If there's an opening in St. John 4 or 5 years later, it's a seniority system. This, if I were a suspicious person, this smacks. It smacks of somebody wanting to be a judge and wanting to decide where they want to live. It is the executive branch of government meddling with the judicial branch. It is something that the Supreme Court of Canada has said is unconstitutional. It doesn't pass the smell test, depending on who is the Premier of New Brunswick. We have a Premier in name, and we have a de facto Premier. So, depending on which is calling these shots, it's just smacks. The legal community knows it's a farce. You know it's a farce. People around you know it's a farce. I know it's a farce. It's despicable behavior. The Attorney General knows it because he's an honorable person. He's taken a legal position, which he believes it's his position to take. There's nothing here compelling the people around you to answer my questions. I can't subpoena anyone. I can't ask anyone under oath. The whole legal community knows what this is about. The province knows what it's about. You know what it's about. It's disgraceful. Those are my questions. Thank you.
Is there any other members that want to ask questions? No. Then, je demanderai au ministre si qui a...
Then we'll ask the minister if he has any closing remarks. Yes, Mr. Chair. I would simply like to repeat that I'm very proud of leading this department with individuals that are very competent, that I'm very happy to work with on a daily basis. And I'm generally in agreement with the member opposite, I'd say generally speaking, but there's always exceptions to that rule. And so I'll keep my comments to that and thank the member opposite for his questions and be rest assured that people within my minister are doing their work and are respecting the laws and the Constitution of the country when they do so. Thank you, Mr. Chair.
Now to leave the chamber so we can take a vote.